we're obviously trying to reach out and help wherever we can at the moment. So this session we thought would be quite helpful just in terms of giving an overview of the issues that we're seeing, the stories that our clients are reporting to us, and how we're trying to help overcome those issues wherever possible. Towards the end of the session, there will be an opportunity for everybody to share any experiences that they might have had, because I'm sure we can all learn from those of you that are very much on the front line, and also, of course, to ask questions. So if there is something that you'd like to contribute, then by all means make a note of that, and we'll come to you at the end of towards the end of the session. For the moment, though, I'll pass you over to David, who's got some interesting topics that he wants to talk through, and then I'll work through one or two things that I'd like to cover as well. So over to you, David.
Thanks, Tony. Thanks everyone for joining us. Hope you're all okay. I can see lots of healthy faces in front of me. Usually in my presentations, I attempt some jokes just to lighten the mood a little bit, because legal issues can be a little bit serious. And because you're all on mute, I'm not going to be able to hear all your laughter. So that's kind of what I'm used to, having dead silence as I put a joke across and watch the tumbleweed roll across the road. Haven't got any showy books behind me, but I do have maps. And actually, I do refer to them quite a lot. It's just quite useful to when you're dealing with properties, as I do all over the UK. It's just good to have a sense of where everything is and where things are taking place. Couple of minutes about me. I am head of litigation here at Napthans, specialising in commercial property disputes, and just generally when things get tricky, I can advise on strategies, and hopefully come up with some no-nonsense practical advice for clients, rather than giving them too much legalese. My experience goes back about 20 years of dealing with commercial property disputes of all kind, but it's mostly commercial landlord and tenant, and that's what I'm going to focus on today. So just a quick recap of where we are and how we got here. It's all been a little bit of a blur. I know it's hard for me to think back even a few weeks as to what the rules were and where we were up to. But 16th of March is when the government first announced that people should avoid offices, pubs and public gatherings. You might remember that weekend when everyone flocked to the pub. 17th, Rishi Sunak announced his 330 billion package of measures. 18th of March, the schools closed. But then on the 23rd, we all entered this phase of sort of full lockdown. I'm not going to discuss the different levels of government support. I think everyone's pretty familiar with those by now. Neither am I going to talk about private landlord and tenant and the residential sector. That's a huge subject in itself, with its own sort of special restrictions and provisions. What I would recommend, and this is something that I only did a couple of days ago, if you haven't done so already, is register on the government website so that you get daily updates. I mean, as I said to Tony earlier, if you go on the COVID-19 government website, it's pretty amorphous, hard to navigate, because all that information is just being put on an almost daily basis. And it's quite hard to keep track of what the different measures are. So I would do that. You will then get a daily update by email, or if there are more than one a day, you'll get an update as and when something happens. So that's useful, I think, for everyone to register for that. Just something to say, although I'm not going to talk in detail about as I said, about the various provisions for helping businesses. What's currently interesting for commercial property is that the government, I think some of you will know this, the government is currently considering what they call a furloughed space grant scheme. A few of you are nodding about that. This is basically still under discussion at the moment with the government, and it's an idea that's been borrowed from, I think, Scandinavia, Denmark and Sweden specifically, whereby the government, similarly to the furlough scheme for employees, the government is possibly going to subsidise rents, commercial rents, from tenants that are currently unable to trade, retail, hospitality, I'm sure. So that's something to look out for. From my point of view, as I say, I am going to focus upon the recent changes in the law of commercial landlord and tenant, and particularly remedies for non-payment of rent. That affects most businesses in the country, and most businesses do still rent space. Over the years, I've acted for large commercial landlords and commercial tenants, so I've seen it from both sides of the fence, as it were. So first of all, the major change, and it's probably one of the most immediate sweeping changes we've seen in the law for, well, as long as I can remember. We've now got this Section 82 of the Coronavirus Act, which is essentially, well, they're calling it a moratorium on forfeiture for non-payment of rent. And essentially it means that landlords now cannot forfeit for non-payment of rent during the relevant period. And the Act and a lot of other rules and regulations use that relevant period, which ends on the 30th of June. So they brought this in on the March quarter date, the 25th of March, obviously to prevent landlords forfeiting for non-payment of rent for that quarter. Most leases will allow a tenant 14 or 21 days grace before forfeiture can take place. But straight away on the March quarter date, the government has said, right, no more forfeiture for non-payment of rent for business tenancies. Now, there are a few devils in the detail there. It only applies to leases, to business leases. Doesn't apply, well, business leases that are classed as business leases under the Landlord and Tenant Act 1954. So doesn't apply to licenses, and it doesn't apply to tenancies at will. Tenancies at will you can terminate anyway. You don't actually need a forfeiture clause. So what is forfeiture? If you don't know what it is, pretty much it's the most powerful weapon in a commercial landlord's armoury. For as long as I know, I've been advising landlords and tenants upon the forfeiture right. Handled a lot of forfeitures on behalf of landlords, and it is a pretty decisive weapon. For non-payment of rent, you don't have to issue court proceedings. You can just, once the relevant period under the lease has expired, for them to pay the rent, you can change the locks, and then the tenant has to make an application to the court for relief if they want to get back in. Used to have an assistant working for me who got very excited when he knew that he was coming in to work, and he was going to be dealing with a forfeiture that day. Don't know why. It's just the kind of guy he was, I guess. Because you would always get the tenants on the phone that day, saying, "Right, okay, I'm sorry, we're gonna pay the rent after all," and their pleas of poverty and inability to pay the rent at all suddenly disappeared, and they were able to find the money. 10. So, as I say, Section 82 is the main restriction at the moment, preventing landlords from being able to forfeit. The only sort of SOP that's been given to landlords is that during this relevant period, they can't waive the right to forfeit for non-payment of rent. That was usually something that you would advise. I've been advising landlords on over the years that when a tenant hasn't paid its rent, you've got to be very, very careful what you do so as not to unequivocally recognise the continued existence of that lease by demanding further rent, for example, for future periods, or by pretty much dealing with the tenant in any other way that recognises that that lease is still on foot. So that's the only, like I said, that's the only sort of comfort for landlords during this period. Also, Section 82 says that if proceedings have already been commenced for possession by forfeiture, then no orders for possession will be given again until after the 30th of June, this relevant period. The other main provision that I wanted to talk about is one that the government has been telling us about since the 23rd of April, but we still haven't seen it yet. This is the provision which was announced that says that statutory demands and winding up petitions will essentially be outlawed as well. Statutory demands, I think, from the 1st of March, winding up petitions, not allowed to present those from the 27th of April. We've been in discussions with the House of Commons direct on a daily basis, and we still don't have an answer. I think our trainee found a mention of it on Sky News, of all places, that it was going to be this bill, it's called the Corporate Insolvency and Governance Bill 2020, is going to be laid before Parliament this week, but they said that 2 weeks ago about the following week. So, you know, who knows at the moment. The focus on it, and there have been actually 2 cases which are pretty interesting. The focus on it is only against companies. So this is to stop landlords who are obviously running out of remedies, to stop landlords being able to issue statutory demands. These are demands which create a position under insolvency law whereby the tenant is deemed insolvent. So that's why they serve a statutory demand. It gives 21 days for the tenant to pay the arrears of rent. And that is then usually followed up, if the money's not paid, by a winding up petition using the strength of the non-payment of the statutory demand. I act for a couple of large retailers, national retailers, who have been hit with a swathe of these over the past few weeks. It's very difficult to advise in circumstances where when the landlord gets to court, there could be a law which bans what they've threatened to do, but there might not be. So how do you advise a tenant in those circumstances? It's very, very tricky. There have been 2 cases one of which I don't think is fully reported because it's subject to some confidentiality restrictions, so I can't actually get the details. But the upshot of it is that there's been a recent case where a tenant didn't pay. Well, I think it was a company that didn't pay a sum of money. I think it was a liability order, and a winding up petition was issued against them. They applied to court for an injunction to prevent the presentation of a winding up petition, and the judge said, well, this legislation isn't in yet, but all the government statements that have been published strongly suggest that it's got nothing to do with anything other than non-payment of rent. And also the indications from the government were that there's going to be some sort of a threshold test. In other words, you've got to show that you, as a tenant, are in financial difficulties, and that's as a result of COVID-19. But we don't know for sure. Then more recently, there's this case, as I just mentioned, which we don't have the full details of yet. But apparently that case, in that case, the judge said, well, the legislation isn't out yet, but you are a tenant. You are obviously being pursued for non-payment of rent. So I'm going to use my discretion. I'm going to grant this injunction, stopping the winding up petition being presented, because I think that you fall within the category of what the government has in mind of who to protect in this legislation, but it's still not out yet. The likelihood is, I would have thought, that it's going to come in within the next week or two, but it again is steering landlords and tenants towards discussing more openly what to do about rent, and to be more reasonable with each other and come to some sort of accommodation. I've seen landlords at one end of the spectrum who have got no tolerance whatsoever for anything other than being paid in full, and I've got tenant clients at the other end who are also saying that they're paying nothing, and most of the time it's somewhere in the middle, but it just depends upon the circumstances of each particular case. What I've been saying to both landlord and tenant clients in this situation is, well, just look at each set of facts separately. Look at the lease, look at the financial position of the tenant. The tenant should be open with its financial information about how COVID is affecting it, and you need to look at all the different ways. There's no one size fits all the different ways that you can try and come to some sort of a deal or concession during this time. I've seen all kinds of different deals, 50% of the rent, let's say, during this period up to the end of June. I've seen complete deferrals. I've seen national tenants who are saying, right, we're not paying rent for 9 months, but what we'll do is we'll extend the lease by 9 months. I've seen tenants threatening to exercise the break clauses if a deal isn't done, which is something else I'm going to come on to in a minute. But the main message, as I say, that I'm giving to all our clients is, you've just got to deal with each set of circumstances on their own merits and carefully look at all the information that you've got. Look at the financial support that's available to the tenants as well, and factor that in to coming up with a fair deal. Just some other restrictions as well, which are worth mentioning. Enforcement agents at the moment, under what used to be the old distress power, whereby a landlord would be able to seize tenants' goods for non-payment of rent. That has been restricted also in the commercial landlord and tenant field. There must now be, instead of a minimum of 7 days unpaid rent, and this is only principal rent, must be a minimum of 90 days now. So again, you can see how the government is trying to shelter tenants during that 3-month period. I mean, in any event, another point worth mentioning is that all possession proceedings have been stayed pretty much until after the 30th of October at the moment, as well as possession orders. So there's sort of the procedures under CPR 55. So they put the brakes on possession proceedings as well. The other provision that's been brought in by practice directions is that parties now in litigation can agree extensions of deadlines by 56 days, up to 56 days, which doubles what they were able to agree without going back to the court prior to the new practice direction coming in. So other remedies that landlords and tenants need to be conscious of when the sort of standard traditional remedies look like they're being restricted even further. Guarantors is one thing to look at. If you are going to enter into any sort of a deal as a landlord with a tenant, you need to involve the guarantor. There's too much of a risk that if you enter into a deal with the tenant, then a guarantor is going to be able to argue that that thereby releases them from the guarantee. The rules on that are pretty complicated. I won't go into them, but you've just got to join a guarantor or guarantors in to any concession deal that you enter into with the tenant. That's a must. Rent deposits, obviously, something else to look at. Query whether you want to dip into it now, because usually there's an obligation for the tenant to top it up. But obviously something else to look at. If there's been a previous assignment of the lease to the current tenant, you've got to look at the previous tenant's guarantee, because they will usually give a guarantee under an AGA, authorised guarantee agreement. And you've got to be aware that if you do pursue a previous tenant through an AGA or a previous tenant's guarantor, then you've got 6 months to serve a requisite statutory notice upon them. Otherwise, you lose the right from when that payment falls due. You lose the right from use the right to be able to recover that from the guarantor. This is, I mean, Tony's going to talk a little bit more about where we see the commercial property landlord and tenant market going, but certainly, and I was reading an article in the Telegraph a week ago, certainly there's going to be a bit of a shift in the dynamic, I think, going forwards between landlords and tenants. Landlords have had it pretty good for the past decade or so. Leases are still 4/5 about tenant covenants, and then there's a bit usually at the end with the landlord's covenants in there. I do think that certainly with changes to the office market, people more able in offices now to work from home, we're going to see changes to the relationship between landlords and tenants, which perhaps put them on a bit more of an equal footing. So that's my bit. I'll hand back to Tony.
Lovely, thank you, David. For those of you that don't know me, I've been at Natsons now for just over a year. I was brought in to help our commercial property team in Sefton and West Lancashire, so I'm based at our Southport office. And although I've got clients, as we all do, up and down the country, and in fact, some overseas, probably fair to say that the majority of my clients are located across Sefton and West Lancs and the Northwest generally. I just wanted to run through some of the things that I'm seeing in the marketplace based on my own experiences, based on what I'm seeing and reading in the media, and of course what our clients are telling us as well. Starting with lenders, there have of course been one or two issues with lenders over the last 2 or 3 months. Existing applications for secured lending have been stalled for them, in some cases at least, largely just because lenders have been so preoccupied dealing with their existing customers' requirements in what are, of course, extremely challenging times, and of course processing the business interruption loan facilities as well. So although based upon the conversations I've had with banks and lenders, there is still very much an appetite. It's not so much a credit issue that we're dealing with at the moment, it's more a service issue and just a general lack of capacity. As we hopefully now start to come through the worst of the disruption, although obviously there's going to be some tests ahead for all of us, hopefully we'll see part of that problem resolve itself, and lenders will now be in a position to pick up either applications that were already in the process of being looked at and dealt with, and they'll be throwing the doors open, I imagine, for new business as well. So that's encouraging. The other issue as far as the lending side of things is concerned, of course, and this is well documented, is the practical problems of having the property valued in relation to an acquisition. It's been difficult, if not impossible, to arrange for valuers to carry out their surveys of properties in the way that they would normally, just because of the regulations and the restrictions around social distancing, of course. Some lenders have moved towards desktop valuations, or what are sometimes known as drive-by valuations. I will say my experience of that is that it's only in very limited circumstances that they look to rely upon that type of arrangement. It's perhaps more prevalent in residential property as opposed to commercial. But now, of course, off the back of Boris's most recent major announcement, and people being encouraged to go back to work wherever possible, the news is that valuers are now more able to get back out there, and hopefully that will clear the backlog. It will take time. There's obviously some issues in terms of catching up, but nonetheless, hopefully now, from a lender's perspective, we'll start to see some movement, and of course that's critical for most acquisitions. A lot of buyers are mortgage dependent, so that should help stimulate some activity in the marketplace. Just sticking with lenders for a moment, some of the people that I'm speaking to are suggesting that they're now looking at a couple of different things, which is likely to be relevant to a lot of people. One is their criteria. So they're now re-examining what they would want to see in place as far as things like serviceability and affordability. And certain lenders are also just looking again at their loan to value ratios. So it'll be interesting to see how that plays out, because I think although there'll be a real demand for what these guys have to offer, it'll be interesting to see, especially in the current climate, how many people will be in a position to fall within the parameters that the bank is setting out. Moving on from that and looking at other issues that I think the commercial property market is faced with or will be faced with, the obvious one is what will happen insofar as capital values are concerned. And nobody seems to be entirely clear about this, not least because, of course, there's still so much uncertainty as to how long this will continue for, and what the net effect of it will be in the months and years potentially to come. But I think there's a general consensus that capital values of properties are likely to be hit by the pandemic. Some people are saying 10 to 20%. It depends on sector, it depends on geography, it depends on all sorts of different factors. But that of course is likely to play a part in terms of how active the market is over the course of the next few weeks and months. Linked to that is how motivated sellers are. So do they need to sell, in which case maybe they can take a view of the fact that the value of the property and what they're likely to achieve for it is likely to be less now than it was a few months ago. Others who are perhaps slightly less motivated may well choose to retain the asset until such a time as the market takes steps to recover. But all of these things are likely to have an effect in terms of the levels of activity that we see. One or two other things that I'm seeing as well from surveyors is that there's now some wording that's appearing in a lot of valuation reports that to some extent qualifies the extent to which the comparable evidence can be relied upon. So it goes back again to nobody's quite sure as to the effect that all of this is likely to have on values, and we won't know that for a little while, I don't think. But usually part of a surveyor's report, quite a big part of it in fact, talks about the value of the property, the reinstatement value and such like, the rental value, and it gives various examples of properties that are similar to the target, what they've been sold for, and so on and so forth. And surveyors are now inserting a sort of semi-disclaimer around how accurate or the extent to which lenders can hang their hat on those types of opinions. So again, interesting to see what lenders make of that in the weeks and months to come. Just talking a little bit about sectors. We act for some fairly prominent developers in the construction sector, of course, and fair to say that the stories that I'm hearing from those types of clients is that they've been less affected than some others, depending upon the nature of the development and the stage it reached prior to the lockdown. Commercial developments at a relatively early age tend to be, a lot of our clients have found that they're able to continue with the build, of course, whilst practicing social distancing. And perhaps it's fair to say that with construction, a lot of properties, newly constructed properties, are already either pre-sold or pre-let. There's an awful lot of deals that are done fairly early on in terms of the construction process. There are, and there will be, just the final point in relation to the lending process, opportunities for those people who are less dependent upon secured lending. So although there will be an awful lot of challenges ahead for a lot of people, if clients or buyers, even tenants, are in a position where they have resource or relationships with their banks and lenders whereby facilities can be made available, then obviously there are opportunities to cash in on there. The agents, some of the property agents that we're speaking to, as of the last couple of weeks, are reporting increased levels of activity, both in terms of property coming onto the market and inquiries, the rate at which they're receiving inquiries in respect of their stock. So the suggestion, although it's still very early days, is that over the course of the last couple of weeks, people are now beginning to get back, not necessarily to any level of normality, but at least we seem to be taking steps in the right direction. Those activity levels that are being reported by the agents, together with the view that lenders are now taking, value as increased capacity. Again, I think it all bodes well for in terms of helping deals move forward. I just wanted to pick up on something that David spoke about, which is the relationship between a landlord and tenant. We would always encourage, and it's obvious really, we'd always encourage open and clear communication between landlord and tenant. It often helps the relationship just during the course of the term of the lease. But I think now more than ever, That's absolutely critical. There are discussions taking place the length and breadth of the country, largely aimed at rental concessions, whether they be rent-free periods, whether they be deferments. I think the one point that I would want to stress, and again, I think David touched on this, is communication. Yes, have your conversations with the landlords and your tenants as early as possible in the process. And hopefully, if an agreement can be reached, document that agreement, have it absolutely clear as to what's been agreed, how long any abatement or concession is to last for, and what might trigger going back to the original position. Important that all of that is recorded in the appropriate manner. David also mentioned rent deposits, and I'm seeing more and more conversations between landlords and tenants result in rent deposits being utilised. Yes, there is, or there should be at least, rent deposit deeds that sit in the background that explain how those monies are to be held, how they're to be retained, circumstances in which they can be dipped into, and when ultimately, or if they're to be returned to the tenant. This type of situation doesn't really lend itself to rent deposits being utilised, other than ultimately the monies are there to allow the landlord to recover what's owed to him without necessarily having to chase the tenants all over town in order to get paid. But what I'm finding is that landlords and tenants are coming to an agreement whereby the rent deposit will be used now to cover the rent, and an agreement is being put in place to record again when that rent deposit has to be replenished. So it will have to be topped back up to its normal level in accordance with the terms of the deed. But I'm finding that landlords are prepared to allow an amount of time for that to happen, just to give tenants a little bit of breathing space. Something else that I'm hearing a little bit about at the moment is within a lease, there's quite often fairly detailed provisions around rent suspension. So if certain events occur during the term of the lease, the tenant doesn't have to pay any rent until things settle back down again. It's usually in relation to damage or destruction of a property. If a tenant can't use the property, can't operate from it, or even if common areas, for example, have been damaged to such an extent that a tenant can't get access to the property, then the rents reserved by the lease, to one extent or another, are quite often suspended. It's worth checking leases to see whether those rent suspension clauses allow for rent to be held back if the property can't be used and occupied. It's quite a lot of what we're talking about at the moment is quite niche, I suppose, because none of us have ever seen anything like this before. But there are one or two commentators out there who are suggesting that if you have a good look at the lease, have a look at the rent suspension clauses, and see if there's anything in there that allows tenants to withhold rent on the basis that they can't use and enjoy the premises in accordance with the terms of the lease, something to look at. Obviously, we're seeing a lot of tenants at the moment looking for opportunities to exit their lease. We're also seeing some buyers that have exchanged contracts in relation to the purchase of commercial property, looking for possible exit routes as well. David, I just want to come back to you on this very quickly to talk a little bit about frustration and force majeure. It's something that's been heard a little bit about over the course of the last few weeks. Do you want to just add a little bit of commentary on any experiences you've had in that regard?
Yeah, I mean, again, it's unlikely that frustration is what you term a common law doctrine, which applies to a relationship between two contracting parties, where performance is made pretty much impossible. Again, I mean, this is related to something that I'll come on to in a bit about business interruption insurance as well. It's still not been tested. whether this pandemic is sufficient to create a situation which would allow a tenant to argue that the lease has been frustrated. In theory, the tenant can still use the property. It's not necessarily made impossible for the tenant to use it, even though it's pretty much made it impossible as a result of the government measures for them to do what they were intending to do and what the user covenant under the lease allows them to do. But the word at the moment is that forfeiture is unlikely to apply. But until someone takes a case to court, we don't know. With force majeure, different doctrine, that relates to what the parties themselves provide in the contract for the circumstances which will trigger usually suspension for a time period of their performance of their obligations under that contract, in this case a lease. So that is a force majeure clause is something that you'll find most in supply of goods contracts, rather than in something like this, where the supply is, there you go, you've got a property for however many years. So the leases that I've seen, even the sort of 75 pages, generally speaking, don't have what could be classed as a force majeure clause in there. I bet they will in the future. I mean, this is what always happens. I mean, years ago, I keep saying that years ago, and it's kind of old, but going back, leases used to be what, 5 or 10 pages long for a commercial lease, and now you look at the standard commercial lease, and it's it's, I would say the average is about 40 pages plus, because as things happen in life and in business, circumstances which parties didn't anticipate happening, they then obviously have to provide for them in the contractual agreements going forward. So there's going to be a number of changes which are going to come into leases, but force majeure is not something that's likely to be relevant. Tony touched upon rent suspensions, but again, I mean, that's usually as a result of an insured risk event happening, and again, depending upon how it's phrased, where it makes it completely impossible for the property to be used. But again, until someone has a lease with a particular clause in it and decides to take someone to court over it, then there's no real answer to that. One thing that I did want to mention just quickly is some of you might be aware that the Financial Conduct Authority has actually, I think they've actually issued the High Court proceedings now, seeking a declaration that the business interruption insurance clause in an insurance policy where they have the kind of highest level cover. If you've not got the cover, then forget it. But if you've got the higher level cover, the Financial Conduct Authority have issued a claim for a declaration, or they're about to, seeking a finding from the court as to whether an insurer should pay out as a result of COVID-19. So that's worth looking out for as well. I would just keep checking on the FCA website. That's going to have a massive impact on commercial tenants. And my understanding is that the FCA wrote to some of the big insurers and asked them to explain to provide a copy of their clauses in their standard business interruption policies, and to explain themselves, as it were, as to whether and why someone wouldn't be able to make a claim on that policy. That's obviously for an occupier primarily. So yeah, that's worth looking out for.
Okay, thanks, David. Just one other very quick point before we move on to what we think we're likely to see in relation to commercial property matters going forward. And something that David touched on earlier is break clauses. An awful lot of people have fallen foul of break clauses in years gone by. And I would suggest that's predominantly because they haven't necessarily either checked the clause within the lease as closely as they should, or they haven't taken advice before attempting to exercise the break clause. Depending upon the circumstances, it's a one-time opportunity for a tenant to exit the lease. So if it's exercised in the wrong way, people can be faced with a situation where they're tied in for what could amount to a number of years. Break clauses usually contain a number of conditions, all of which have to be satisfied and completely discharged before a landlord can be obligated to allow the tenant to move on. And some of them are extremely finicky, even down to the way in which a written notice has to be sent to the landlord, the postal method that has to be used. It's a bit of a minefield. So there will be, I think, a growing number of tenants looking at their leases, looking at what options they have in terms of allowing them the opportunity to exit the lease, and the various hoops that they might have to jump through in order to achieve that objective. So,
can I just nip in on how finicky the courts are on that?
Yeah.
I can't remember which case it was, but the judge said in this case that break clauses are very, very strictly interpreted against the tenant if the provisions of the break clause say that it's got to be served on green paper. It has to be served on green paper. Otherwise, it's not valid. And I've had lots of cases where we've had to deal for a tenant with a so-called impossible break clause, which just has so many conditions that the tenant has to comply with in order to even, to be able to break the lease from how the thing is served in the first place, to what covenants have to be strictly complied with. There's been a famous case about interest. The lease provided that the tenant had to pay everything that was due under the lease, and the tenant was late. I think the interest was something like 100 quid or something like that. But because of the strict provisions of the break clause saying that they had to pay everything, even though they didn't have to demand that payment of interest, then that invalidated the break clause. So just two examples of how.
Well, yeah, exactly. And I think maybe it's fair to say that in years gone by, small imperfections in terms of how a break clause is exercised, the landlord may have been inclined to take a view of that. Going forward, I think there's a real possibility that they'll take a different view. Landlords, of course, are looking to try and retain tenants wherever possible, trying to attract new tenants to vacant premises wherever possible. So certainly from a tenant's perspective, the wording and the requirements of any break clause that they might have the benefit of needs to be checked extremely carefully. And again, they should get qualified advice before attempting to take that forward. Just to touch on, before we throw things open to questions, a few things that we think we might see going forward. One of them is businesses looking to move to smaller premises, to relocate to smaller premises. And there's a couple of possibilities there. The obvious one is to sell and to downsize. But of course, you've got to find a buyer in what is likely to be a challenging market. Another possibility is a subletting of parts. So rather than sell or transfer, assign your lease of business premises, you might be in a position whereby you can sublet part of it. Again, important to, one, check the terms of a lease as to what the alienation provisions provide for. It's fair to say that most leases prohibit subletting of parts, So good early open communication with landlords is essential to see whether, in what are fairly unique circumstances, whether a landlord might be prepared to allow that to happen, irrespective of the fact that the lease prohibits it. David talked a little bit before about forfeiture. I had a conversation with a client as recently as last week who really wasn't getting anywhere with their landlord in terms of trying to agree a temporary deferment, not even an abatement, just a deferment of rent. And she's now come to the conclusion that she's just simply not going to pay it. Not to be difficult, but just she just doesn't have the means to be able to pay it. The thing that I wanted to comment on there is, in normal circumstances, that's met fairly head-on by landlords, perhaps along with the way in which a tenant is repairing and maintaining premises. The rent is obviously the most important point from a landlord's perspective. So if it stops being paid, it tends to be jumped all over. David mentioned that forfeiture is the most serious remedy that a landlord can look to pursue and that the tenant can be on the wrong end of. It'll be interesting going forward to see the extent to which landlords exercise that remedy, because of course, if they do so, empty premises, which is what a lot of landlords are likely to be faced with, brings with it all sorts of problems. The obvious one is a lack of rent, a rental void. Business rates is something there's been a real change in the regime around business rates over the last couple of months, and those changes will be in place for the months ahead. But in normal circumstances, if there are already business rate liabilities attaching to a property, then after a period of time, they will revert to the landlord. So not only is the landlord not getting any rental income, but he's actually having to shell out for a property. There can be difficulties with insuring empty buildings as well. Some insurers aren't overly keen on that type of scenario, or at least it will make a difference to the sorts of premiums that they're prepared to put out there. And of course, there's likely to be at least a possibility of a reduction in the capital value of the property if it's vacant as opposed to tenanted. David, do you just want to talk a little bit about commercial rent arrears recovery? Because in the absence of a landlord looking to forfeiture in the way that they perhaps otherwise would, there are other remedies available, this being one of them, although again, it's operating slightly differently at the moment.
Yeah, I think I mentioned before that it's still available. I don't think that's going to be touched by this bill that we've not seen yet, because it was already the rules on commercial rent arrears recovery, which for the new style and what replaced distress for rent. So you don't call them bailiffs anymore. You call them enforcement agents. But they do pretty much the same job. My understanding is that it has restricted landlords to only be able to use it. They have to serve through their enforcement agent a 7-day notice on the tenant before they go in and try and seize goods. There has to be 90 days worth of rent outstanding. So I'm not sure yet whether that's being touched by the bill, because we've not seen the bill. But it obviously it's got its own problems. It's useless if there's nothing there that's worth taking. There's always been a problem with distress or commercial rent arrears recovery. I used to use it a bit in the past, and more often than not, you just find that if tenants haven't paid the rent, then that's usually because they are struggling. So if you turn up with an enforcement agent, bailiff or whatever, even if you turn up with a truck, you get a call from the bailiff and they say it's just the cost of removal are just going to exceed the value of what's here. So, I mean, my experience has kind of taught me over the years that as I said before about these deals that landlords and tenants do, you need to look at every job on its own merits and look at all the information, all the facts of the landlord, the facts of the tenant, the facts of the property, the facts of the lease, obviously. And you need to tailor your advice and your strategy to those specific facts. It's it's very much a bespoke sort of thing. The only real remedy that remains, of which that's not been touched at the moment, apart from the ones that I mentioned before regarding rent deposits and guarantors, is a good old-fashioned money claim. So money claims online, pretty straightforward and easy thing to use. We use it. So it's just a straightforward county court claim for the rent arrears. And at the moment, the courts haven't touched that. The only problem with the courts at the moment in general is if they've got a list of priorities, list of cases that they're going to deal with, a list of matters that they'll deal with in priority to other stuff. And like everyone else, they're short on hands at the moment. So some courts have closed, some courts have merged with others. So the general, even though the courts have said the wheels of justice have got to keep on turning, sounds like an easy rock song, doesn't it? Even though that's been said, the actual reality of it is, it's more like a sort of a tractor at the moment, and I've had one recently, a straightforward application where ordinarily I'd be able to make it to the court. It would be dealt with on paper because it's so obvious that we should get what we're asking for. And the court have listed it for a telephone hearing on the 30th of July. So, that's the reality of courts at the moment. So even as I say, that county court claims for rent arrears and other arrears of insurance, rent, service charge are pretty much all that's been untouched at the moment. Doesn't necessarily mean that it's going to be as slick as it used to be.
Yeah. Okay. Just by way of just to wrap things up, I'm conscious that we've been yammering away now for over an hour. In terms of sales of commercial property, we talked earlier about one or two challenges that the market's likely to face. I think one of the key issues is the extent to which sellers are prepared to accept a new reality, I suppose, both in terms of appetite, demand, and what their asset is realistically likely to fetch in the market. Similarly, in terms of the landlord and tenant market, I think landlords will, perhaps now more than ever, just need to take stock in terms of regards the terms on which they're prepared to offer tenancies to prospective occupiers. I think we'll see an awful lot more rent-free periods. We may even see landlords contributing towards fit-outs, tenant alterations. We're almost certainly likely to see shorter contractual terms, or at least more break clauses worked into new leases to allow tenants greater flexibility. Landlords will take a really close look at prospective new tenants, regards their financial standing and their covenant strength, how their business has performed, how it's ridden out this particular storm, and what their experience is generally. Retail obviously has its own problems. Those are pretty well documented, and none of what we're experiencing at the moment is likely to help that. I just wonder whether we might see more businesses decide to now move online as opposed to having fixed premises from which they trade. And if they do, then it won't help the retail sector, but it may well stimulate warehousing and industrial space. Some of my clients in leisure and hospitality are obviously extremely concerned at the moment, not least because that's obviously for the most part quite a seasonal type of business. And although there's talk about businesses in that space being allowed to reopen shortly. Quite when that will be and how it will look, we're just going to have to wait and see. I think there's an argument to say that some of my hotelier clients, the prospect of them being reopening, throwing the doors open again on a restricted capacity basis, on the one hand is positive, but on another, you just wonder whether trying to work with your hands tied behind your back like that, what impact that will have insofar as profit margin and whether it's actually viable. We're talking about hotels operating at 30% capacity. How workable that is, again, depends on people's circumstances, I suppose. David mentioned before about office space. I think that is something that I think is likely to change fairly considerably over the next few weeks and months, and maybe even years. I think there's a lot of businesses out there that haven't necessarily appreciated that they and their workforce could operate remotely, can work from home. Of course, most of us have had to adapt and innovate and overcome various challenges. And I'm sitting at home now. I know, David, you're in the office, but it'll be interesting to see quite what the office space looks like going forward. I think also, aside from trying to reduce your operating costs, there may well just be a demand from employees that have gotten a bit of a flavour actually of working from home and quite like it, quite like flexible working arrangements. So of course, every business wants to keep its staff happy. The extent to which they can and choose to accommodate that type of working arrangement in the future, let's wait and see.
I was just going to mention there as well. I think therefore it's going to affect the recruitment.
Yeah.
As well. I mean, it's something that's close to my heart. You know, because we've been expanding quite rapidly. I'm on the lookout for another assistant, and the sell of Preston, as opposed to Manchester or Liverpool, is sometimes quite difficult. You know, to get people to work in Preston. But I think that's going to be less of a problem, and that's going to be one positive thing going forwards. So, you know, I'm pretty excited about that, actually. That's one positive thing.
Okay, well, I'm not sure I've got anything else I want to say for the time being, unless there's, anything else you want to add, David, before we throw things open to questions? Or
No. If anyone wants to share experiences, ask questions, happy to take them. If not, we'll put the kettle on.
Do we have any questions at all?
We've had no questions come through the chat, guys. But if anyone does want to ask a question, they can feel free to unmute themselves.
Hi, David.
Yes, hello.
I just thought at least ask something, unless you guys are sitting there comfortably, we make you a bit uncomfortable, I think. That's my joke. I'm not being serious.
Oh, right. Oh, sorry. Yeah. Thanks, Mohammed. Yeah, if anyone's got any questions that they think of later while they're making a brew or whatever, then just give us a ring or just.
David,
I would just ask,
I'm in mainly residential estate agency in Birmingham.
Yeah.
And I was looking at probably going into the commercial sector.
All right.
I mean, obviously it's a difficult time in commercial per se, as what you've explained. What advice and kind of things that I need to look out for if I wanted to tip my toes in that? And the second thing was, if I wanted to kind of work with yourselves as being one of your partners, or maybe as an associate in some capacity in Birmingham, is there any room to do that?
That sounds to me like a chat offline. But in terms of, I mean, you'll back me up on this, I hope, Tony. In terms of the sorts of commercial property that you'd be looking at, I mean, it's it's got to be industrial warehousing, logistic type stuff, hasn't it?
Yeah, I think I'd agree with that. And what I would suggest is have a really good conversation with the property agents that operate in whatever area you might be interested in buying into, because they'll be able to give you some helpful advice insofar as appetite for any particular type of property, how readily you might be able to find an occupier for it if you're interested in vacant. And it's always as well to have regular conversations with agents anyway, just to give them a brief as to what would pique your interest, where your sweet spot is, what they have in their stock that might just fit the bill, and to give you a heads up if anything comes to market that they think you might be interested in.
Okay, I mean, we're estate agents ourselves, and that was a sector perhaps I didn't explain initially quite clearly. So I understand from your point of view as an investor, which I could be as well. But the kind of inquiries that we're having at the moment from our clients is either having small units, storage in the industry, like David has said, and secondly, we have commercial premises like shops and offices, which I believe will become more available after the COVID scenario ends, because people will be probably going bust, which is unfortunate. So we might have a lot more to pick up as an estate agency. So it was on those lines. But I'm quite happy, David, you got my details to pick up the other conversation with yourselves. I have no problem offline. But I just wanted to, see,
register
if I
your
did,
interest.
Yeah.
Yeah. Okay. Right. Great. Yeah.
Hi, David. Hi, David.
Hi. Who's
Hi.
that? Israel.
Hi. Just coming back to Mohammed's about investments. I mean, we're all talking about the office city centre coming to a halt. People are moving out. From my personal experience, what you'll find more small satellite offices on the outskirts of town. So while city centre, people will try and cut the costs in city centre offices, where you'll have hundreds or thousands of people sitting together, you will find more small offices, cheap offices on the outskirts of town, trying to cut down on operation costs. That's where I think we should be looking at the moment. I really don't think it's going to happen where everybody's going to be working from home. And I've written a small post on LinkedIn about it. People need to work with other people. We need that company. We need that social to work with. Otherwise, we'll just end up being a bunch of hermits, and that's not good for our well-being. So I can't see where this home, where you're going to sit in your pajamas from morning to night, not going out. So that's why I don't think it's completely dead. Everyone's talking, well, we're going to, I heard from one firm of solicitor said, we just started now. He said, we can all stay at home. And 2 minutes later, they're gone and rented the office. I said, what's going on? I don't think it's completely dead, the office market. I think people, once the lockdown is back, people will want to go out and go back and meet their colleagues again. We don't want to sit at home doing work. We are a natural, species. We want to meet people. We want that, social.
But I do think there'll be. I'm not saying, and I wouldn't want, like you, I wouldn't want it to, as much as I, like this, I wouldn't want it to be the absolute norm. I mean, what it perhaps does open up is greater possibility for having meetings with clients like this, rather than, say, telephone calls, or where a client's got to travel a long way. The ability to just have a one-to-one Zoom call or Microsoft Teams or whatever with a client or a few clients, once you're used to the tech, is pretty attractive. And certainly for clients who have to travel to an office to see a solicitor, I think that might you might see a lot more of those kinds of meetings. And I don't know how different meeting someone physically face to face is, and the benefits you get from that, compared to seeing them on you know, a 10 or 12 inch screen.
Yeah.
But I think there's going to be more of use of working from home, I think, and more use of the tech for meetings. I don't think we'll see that in the courts. I've seen we have this blog that I get emails from, and the judges. I mean, I know they're a bunch of old-fashioned so-and-sos, a lot of them, but they really don't like having hearings through video conferencing. It just doesn't really work. You know, if you imagine, those of you that have been to a trial, if you imagine how many bodies there are moving around, and everyone's got their eyes on the judge, and then there's the witness, and then there's the advocate that's speaking, and then ushers are moving around and passing documents. That just a colleague of mine in litigation, a senior litigator, he had it wasn't a trial, but it was a long, valuable, contested hearing, and it was very, very difficult. You know, so I don't really see courts embracing it going forwards when things do return to normal. We've always had telephone hearings for straightforward stuff, but anything that's contentious, the tech is not there, and I don't think it ever could replace the workings of a courtroom. It's not Rinder. The reality of it.
David.
David.
David Roper.
Yeah, hi, David.
I think John McGrath's beat me to it on the impact of dilapidations and what this current situation would be. So that was a first question. The second is, I mean, you know, I'm a valuer, and I see this position that we're in at the moment being very similar to the position following the last recession, and coming out of that, and the sort of main pointers were that the values will probably almost certainly drop in certain sectors. Industrial seems to be holding up at the moment for the reasons that have been mentioned, but the difficulties for valuers is valuation accuracy, and there are some comments on the RICS website about this if people want to have a look. There's a limited life to the valuation, and you know, you are at risk if you rely on desktops, and we're going to have to get ourselves into a position where we can do proper inspections. So lending is going to have to just sort of wait, I think, but it will impact. There's no doubt about it. But I'd be interested to hear your comments on dilapidations if you've got any.
To a specific question.
Well, I just wonder what was happening in terms of dilapidations disputes with this current situation. Are they just being put on hold?
No, I mean,
continuing as normal.
Yeah, I mean, I've dilapidations is I've probably 20-30% of my cases.
Yeah.
The ones that I've got at the moment, though, the big one that comes to mind, well, the lease ended, you know, pre-lockdown, and you know, this is why I find that litigation doesn't tend to be affected one way or the other by downturns. The landlord wants his damages ASAP.
Yeah.
And the date, the valuation date that was relevant for the purposes of that claim, and we act for the landlord, was way before lockdown. Yeah. So, you know, the valuation issues that you've mentioned aren't relevant for that. But certainly, leases that are coming up for expiring, where there's going to be a terminal dilapidations claim, that's going to be tricky from a valuer's point of view, isn't it?
It is.
You know, what's the diminishing in value in a COVID post lockdown, but still really struggling commercial property market. That's going to be really, really difficult, I would have thought. But I don't have any cases on at the moment where the lease is about to end and we're looking at terminal dilapidations. They've already ended.
Right.
Or there's no, or I'm doing interims where it's nowhere near the end yet.
But are the courts prioritising dilapidations? They're probably not.
I've got a list of what they do prioritise. I didn't see dilapidations on there. You know, it's
yeah.
Crikey, where is it? It's here we go. Freezing orders, injunctions, antisocial behaviour, homelessness applications, enforcement. I mean, that's why the one that I mentioned, it says number 13 on the list, all multi-track hearings where parties agree that it is urgent. That's 13th on the list.
Right.
And this is just normal civil procedure listings. So that explains why the one that I mentioned earlier, it was actually a request for further information of the other side's defence and counterclaim. Normally just gets pushed through on paper.
Yeah.
And, you know, we've got a hearing at the end of July. So, yeah.
That's good. Thank you very much.
Thanks.
Yeah.
David, I think Terry Parks wanted to ask a question earlier, and I think he kind of didn't get a chance, so I'll try and unmute Terry now.
Yeah, he's unmuted.
It was only if, with regards to a lease coming to its end, and if it was to come to its end during this period of the forfeiture that you were explaining earlier on, whether or not you are still obliged to offer your tenants a new lease.
You're only obliged to offer a business tenant a new lease if it's protected by the 54 Act. So if it's not excluded specifically from the 54 Act. So when that termination date comes along, as long as the tenant is operating a business and remains in occupation, then they will just hold over. And then it's up to them to apply to court for a new lease, but they would first have to serve a Section 26 notice bringing that lease to an end, which is a minimum of 6 months. So if the lease is coming up to an end, let's say the lease was going to end in October, it's not excluded from the 54 Act. The tenant could serve a notice up to 6 months before the end of that lease in October that essentially seeks a new lease, essentially, to start from when the other one ends, although there's usually a period from the end of the lease while they've applied for a new lease. There's usually a carryover period. And the only way that a landlord can bring that lease to an end, if it's not excluded, is breach for forfeiture, as you mentioned, for non-payment of rent. You can still forfeit. This is one thing I didn't mention before. You can still forfeit leases for other reasons other than non-payment of rent. That's not caught by Section 82. So if you do, for whatever reason, want to remove the tenant, you can still forfeit, but for non-payment of rent, you've got to serve them with a Section 146 notice, sets out the breaches, gives them the opportunity to remedy, and only then are you able to forfeit.
Okay, thank you. Okay.
Right.
I think we're probably all done there then.
We're all done.
Just a quick one. Sorry, David.
Chris.
Hi, you okay?
Yeah.
It was just to do with you mentioned, I'll just come back to the forfeiture point again, and
yeah,
it being in this specific period. If then the rent that's due is before, what's the period? When does the start date of this cut off when you can't use forfeiture?
Well, it came in on the 25th of March and ends on the 30th of June. That's the relevant period. So you can't issue proceedings and you can't change locks the non-payment of rent within that period.
Ah, right. So it's not.
It might be extended. We don't know yet.
Right. So it's not to do. It's not to do with if the rent was due in that period. It's just a total block on forfeiture at all.
Yeah. The rent, that's even for pre-existing, which I understand that can be very frustrating for landlords. But I'm acting for landlords at the moment where a lot of the arrears predate, so it can't be due to COVID. But
it's nothing to do with it, but you still cut. Okay.
Yeah.
Right, Joe. Thank you.
Right. All right, Wayne.
Yeah, I think we're probably done now. If there are any other questions, an email will be going out at the end of this session with a recording and David and Tony's contact details. So feel free to contact them separately on anything. And thank you for attending.
All right, thanks everyone.
Thanks everybody. Take care.
Take care. Bye.